All rise. The Court of Appeals for the 5th District of the State of Florida is now in session. The Honorable Carrie I. Evander, Judge, presiding. All persons having business before the court draw near, give attention, and you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Okay, good morning, and welcome to a session of oral argument at the 5th District Court of Appeal. I've already been introduced. Let me go ahead and introduce the other panel members. Seated to my right and your left is Judge Eric Eisnagel from Orange County. And then to my left and your right, we're pleased to be joined today as an associate judge, Judge Stephen Rogers, who hails from Marion County. We have 3 cases on the docket today. Each side will have equal time. The criminal case, each side will have 15 minutes. The 2 civil cases that follow, each side will have 20 minutes. As far as the appellant, if you want, tell me how much time you want for rebuttal when you first get up here, and I'll try to assist you in as far as keeping the clock. Also, if you have any electronic devices, cell phones or anything, make sure you turn them off at this time so that the oral arguments are not interfered with. Now, I notice we only have one attorney so far for the first argument. Okay. Okay. Come on up here then. All right. So we'll go ahead and start. The first case will be Edwards versus State, and Mr. Albert, you may proceed.
Good morning. May it please the court, Attorney John Albert on behalf of the appellant Taylor Edwards. Mr. Edwards went to trial in Brevard County, Florida.
Let me ask you, how much time do you wish for rebuttal?
My apologies, sir. 10 and 5, please.
Okay.
Moving forward, Mr. Edwards went to trial on a 3-count charging information. Count 1 was an aggravated battery with a deadly weapon. Count 2 was leaving the scene of an accident with personal injury. Count 3 was leaving the scene of an accident with property damage. We have 2 arguments before the court today. In the trial, Mr. Edwards was acquitted of the top count but found guilty of counts 2 and 3. Our arguments before the court today, argument 1 is that the trial court committed reversible error in not granting the judgment of acquittal as to the charge of leaving the scene of an accident regarding personal injury. And as to counts 2 and 3.
Did you make the argument below?
Sorry, sir?
Did you make that argument below on the motion for judgment of acquittal as to count 2?
Yes, sir.
What was the argument you made?
The argument was that there was insufficient evidence brought before the court as to a variety of issues. There were some questions as to whether or not Mr. Edwards was the driver of the vehicle, though I don't know that's at issue here today. There were questions as to whether there was an accident. I don't recall the exact phrasing of the argument at the judgment of acquittal, but there was an argument made that what took place was not an accident per se, which of course is the argument here before the court today. I think the case that is most similar to what we have here is the Daughtry case, which was decided by this court. That was at 207 Southern 3rd 980. In the Daughtry case, there was a certified question when a passenger separates from a moving vehicle and collides with the roadway or adjacent pavement, but the vehicle has no physical contact either with the passenger after the passenger's exit or with any other vehicle, person, or object, is the vehicle involved in a crash. And the court held that that did not constitute a crash within the meaning of the statute, and the judgment of acquittal should have been granted. Here the testimony was that Mr. Cowan, who was a passenger in a vehicle behind Mr. Edwards in a parking lot, got out of his vehicle. Mr. Edwards' vehicle went into the roadway. Mr. Cowan went out into the roadway. Based on his testimony, reached into the vehicle in an attempt to take Mr. Edwards' keys. Mr. Edwards was at a traffic light. Light turns green. He pulls away. Mr. Cowan falls away. Does not hit the vehicle, is not struck by the vehicle in any fashion. His actions are what preceded the altercation, if you will, on the roadway. It was his actions of going out into the road, approaching Mr. Edwards' car, reaching into the car and trying to take the keys that precipitated him falling to the ground. The Daughtry case was decided, if I recall correctly, about a month or 2 before Mr. Edwards went to trial. It's our perspective that Daughtry is on point with what happened in Edwards, and in the Edwards case, the judgment of acquittal should have been granted.
Wasn't the motion for judgment of acquittal only made as it relates to the aggravated battery charge?
Sorry?
Wasn't the motion for judgment of acquittal only made as it relates to the aggravated battery charge?
No, sir. I agree that that was part of the state's argument in their brief. However, I disagree with that assessment.
Well, can you cite any language in the transcript? Because I read the argument, and I'm having a hard time finding where the argument you're making now was made below.
The state cites to a portion of the argument for judgment of acquittal where in the first sentence it was said, make a motion for judgment of acquittal as to the top count. That was 2 words in the first sentence of the judgment of acquittal argument. The argument itself lasts about 3 or 4 pages. Actually, I think even further than that, when there were some questions from the trial judge, Judge Earp, as to some issues involving the judgment of acquittal. I don't believe that saying top count in the first sentence of a 3 or 4 page argument means that the entire argument is as to the top count.
Well, did you make any argument that the evidence failed to show that there was a collision or a crash?
I believe there was part of that. I have a portion of the transcript. Let me see if I can find something to answer the court's question as best I can. On page 219, looks like about the 3rd paragraph down, the evidence is wholly unsubstantiated as to that particular issue. The evidence thus far is that Mr. Edwards was in an accident, that he tried to leave that accident because he was under duress. There was an individual next to him that was threatening him. He left that area. He drives out into the roadway. It's Mr. Cowan that intentionally left his vehicle, intentionally left the parking lot, intentionally went into the roadway, intentionally approached Mr. Edwards' vehicle, grabbed onto his vehicle, reached into the vehicle, put his arm through the steering wheel, and attempted to put the car in park and remove the keys. Those acts were all intentional acts by Mr. Cowan. None of those acts were intentional by Mr. Edwards. All of that would apply to the argument before the court this morning as to whether there was an accident that was caused by Mr. Edwards.
Well, does that have anything to do with whether or not there was a crash?
I'm sorry, sir?
How does that relate to whether or not there was a crash and the definition of a crash?
Because it was Mr. Cowan that does everything. It's Mr. Cowan that goes out. It's not Mr. Edwards or Mr. Edwards' car that did anything. It's Mr. Cowan's that went into the road. It wasn't Mr. Edwards that struck Mr. Cowan. It was Mr. Cowan that reached into the car. It wasn't Mr. Edwards that ran over Mr. Cowan. It was Mr. Cowan falling away from the vehicle, much like in the Daughtry case, when Mr. Edwards, on a green light, moves forward.
What if the victim had fallen from the vehicle and instead of not being struck by the vehicle when he fell, what if he had been run over by the back tire?
I think it'd be a different argument. I think under the Daughtry case, then quite likely it'd be a different argument.
But the victim's intentionally going into the road and intentionally reaching into the car really has nothing to do with whether or not there's a crash, right?
I don't think that's entirely accurate. I think that it's accurate.
Well, I mean, certainly the victim could have gone out, done all the same things that happened, intentionally gone out into the road, intentionally reached into the car, and then once he fell from the car, if he had been run over by the back tire, that's a crash. You already said that, correct?
I think the distinction, though, is that then in that situation, Mr. Edwards' vehicle would, in fact, have struck the victim.
Right, and isn't that the only thing that really matters when we're defining the term crash? Whether or not, in this case, the victim was struck by the vehicle. It has nothing to do with whether or not the victim intentionally walked into the road.
I don't know that the roadway itself is important. I think the actions of the victim are important, though, because it's the actions of the victim that put him reaching into the car. If, using another example, if Mr. Cowan were in the vehicle initially and Mr. Edwards is forcing him out of the vehicle, then I think it's different because it's the actions of Mr. Edwards that put Mr. Cowan beside his vehicle as opposed to the actions of Mr. Cowan.
Well, the whole idea of the statute isn't to determine fault anyway. I mean, the purpose of the statute is if there's a crash where someone's injured, that the driver stops, regardless of whose fault it is.
Well, the problem with this statute, though, is it doesn't define exactly what a crash is.
Right, so I think where Judge Eisenhower was going with this question is, you didn't make the argument that there was no evidence of a crash. Whose fault it is really is not determinative under the statute. Now, the argument that there was a crash, there wasn't a crash, that may be determinative, but not whose fault it is.
I would certainly agree that that's the better part of the argument is whether or not there was a crash. And by the Daughtry case, what took place was not a crash.
Let me ask you this. If we determine that the issue is not preserved below, can you still win under fundamental error?
Well, we did not make the argument that it was fundamental error, so I think that would certainly create a problem. That said, I believe that there was sufficient argument made at the trial level to preserve that issue. I believe if the court looks at the totality of the circumstances or the totality of the argument made at the judgment of acquittal, then I think that the argument does in fact apply to the judgment of acquittal. I would also argue that with the Daughtry, based on my research, the Daughtry case was the closest case I could find, and I think it's very, very much on point with our case today. That said, it was the only case that I found that was so much on point with the Edwards matter. Every other case I found had similarities, but certainly had a lot of distinctions
What evidence
as well.
supported the requested instruction for duress and necessity?
Both Mr. Cowan and Ms. Cowan, they were the passenger and driver, respectively, of the vehicle behind Mr. Edwards. They both testified that there was an individual standing next to the car by Mr. Edwards. Mr. Cowan's testimony wasn't terribly enlightening. Ms. Cowan testified that their windows were up, the stereo was on, if I recall correctly, the AC was on as well, and despite that she could hear the individual standing next to the vehicle. She testified that he spoke quite loudly. She testified that he appeared to be under the influence of alcohol. There was also testimony from...
Did she testify that he was threatening in any way?
I don't know that she had the ability to say that. She said that it was loud.
Did anyone have the ability to say that? Was there any evidence?
I believe that there was after the fact. Mr. Edwards' mother also testified. She testified that Mr. Edwards came to her residence very soon after the crash, that he had blood on his shirt, that he appeared disheveled, confused, disoriented, and that it appeared that he had been in some sort of a physical altercation. She wasn't there at the scene, but she did see him shortly thereafter. Our request was that the instruction of duress or necessity should be read, because there was some evidence as to that particular issue. The trial court unfortunately decided it wasn't sufficient evidence, but I don't think that's quite what the argument is. I think...
I mean, doesn't the threat have to be imminent? Well, what was the evidence that the threat, that if there was a threat, that it was imminent?
I don't believe so. I think to make the request for a jury instruction, all we have to have is some bare minimum amount of evidence to establish that the argument might apply. Beyond that, it's supposed to...
You don't have to have evidence to at least arguably establish every requirement of duress?
We do, but I believe
Well, what was the evidence of that the threat was imminent?
Ms. Cowan's testimony that the individual was next to the vehicle, he was speaking very loudly, he was speaking in animated fashion, he was making gestures towards the vehicle, towards Mr. Edwards. He was about as far from the vehicle as I am from...
But he wasn't there was no evidence that he was making violent gestures or
violent,
threats?
Yes, sir. Threatening, in a threatening manner. I don't
Who
recall...
testified that it was threatening?
I think the best evidence for that would be either Ms. Cowan's testimony from the scene or Ms. Edwards' testimony from after Mr. Edwards...
Ms. Edwards wasn't at the scene.
That's correct, yes.
So where did Ms. Cowan say that it was threatening? Can you point me to a page?
I apologize, Judge. I don't have that portion of the transcript with me. I do recall citing in my brief that she said on occasion that he was loud, that she could hear him over the car windows being closed, stereo on, AC being on.
So your position is that loud is equivalent to sort of a threat?
My position is that the testimony as it was sufficient to read the instruction. It doesn't have to have been a great argument, a compelling argument, even a believable argument. It just has to be that there was some amount of evidence put before the court to then leave it as a question for the jury. That was our request.
You're down to 3.5 minutes if you want to save the rest for rebuttal.
Oh, my apologies. Yes, sir. Thank you.
Good morning. My name is Charlene Matthews, here on behalf of the state of Florida. I would encourage the panel to go back and read closely the motion for judgment of acquittal that was made.
Let's assume that it wasn't preserved.
Yes, sir.
And do you think that the cases cited by opposing counsel would otherwise be controlling as to whether there was a crash that occurred here?
No, sir, and here's why. In both Galden and Daughtry, the issue at judgment of acquittal was just a simple insufficiency of the evidence as to one count, or one element, excuse me. neither Galden nor Daugherty applied in or had to deal with an issue of fundamental error, which is a fundamentally different legal
All right,
issue.
well, let's assume that the proper arguments were made at the motion for judgment of acquittal. The argument was, Judge, there was no collision or no crash as defined by the statute or as implied by the statute, and we have this Florida Supreme Court case that says we win. And let's assume that we're here in that scenario.
Okay. I can see at least two ways where a crash occurred in this case, and therefore is distinguishable from Daugherty. In this case, the victim's arm was stuck in the vehicle because it was entwined in the steering wheel. He wasn't holding on to the vehicle like the victim in Daugherty. He was stuck in the vehicle and unable to extricate himself. That is person-to-vehicle contact.
Is that what you're implying, or is that what the witness said? Because I think the prosecutor tried to get the witness to say that, but I don't think the witness was cooperative, if you would.
On page 68, the prosecutor asks, when the car progresses to go forward, does the door jamb of the car catch up to you, and that's how you're holding on? Or are you holding on to the door? And the victim says, no, I was held on by the steering wheel. And then later on, the victim talks about trying to get loose. He doesn't talk about trying to let go. He was...
Counsel, there still needs to be a collision. I mean, that's what the cases say. And so I understand what you're saying, sort of the difference between holding on and sort of being stuck. But where's the collision?
My argument is that the collision was between his arm and the steering wheel of the car.
But isn't being stuck and a collision, aren't those two very different things?
I think the case law requires contact, and that's contact. My second
Well, but contact would just be simply holding on to the car as well. I mean, if it's just contact, then how is then Daugherty is incorrect?
Well, let's say that the victim was leaning up against the hood of the car, just leaning up against the hood of the car. And the driver then decides to go forward and push him over. It's still just contact until there's injury. But it's a person-vehicle contact. I have
But in
another
that case, I mean, in that case, it sounds like what you're saying is the vehicle would actually make contact with the victim with some amount of force, causing the victim to fall over. That seems a little different than a victim holding on to a vehicle or being stuck somehow to a vehicle and then just falling away.
It's unfortunate that the trial court did not have a chance to address this very issue. Perhaps the state could reopen their case. The issue could have been fleshed out and fully addressed, rather than having been raised at the first time on appeal, and we are all working in some sort of a vacuum.
Let me ask you about that. The victim was asked whether the defendant's car struck or pushed him in any particular way during the event, and he said no. And he was further asked whether the right side of his body was up against anything on the car, and he again said no. If they had raised it properly, and what could you have done on reopening? What would the state have done? Say, Judge, we want to reopen. Would reopen to get the victim to change his answer, or what?
This victim was drug at least 50 feet with his arm impaled in a steering wheel. I'm surprised that no injury came out on the record about that.
Well, you might be surprised that he said, he also said there was no contact between himself and the car, so.
And perhaps he wasn't thinking of the actual steering wheel as part of the car, but that is why he could not extricate himself earlier. He was stuck inside that car by the steering
Yeah,
wheel.
but as an appellate court, do we have to accept the answers that are in the transcript and not what you are suggesting is what probably happened, contrary to what the victim testified to?
Again, Your Honor, I believe that the record is clear. On page 68, the victim said, "I was held on by the steering wheel." He didn't say he was holding on to the steering wheel. And later, he talks about having to get loose, and he doesn't really know how he got loose. He says, by the grace of God, he got loose. I would like to advance another argument, and this argument is that this entire short chain of events, short but violent chain of events, were all one criminal episode. That the crash started when the defendant backed in and kind of slid around sideways and hit the victim's vehicle, that's where the crash happened. That evidence satisfies the crash element of the offense, and that while the defendant was still in the process of leaving the scene, he injured the victim. And therefore, the crash took place earlier, and the victim's injuries were resulted from that initial crash. And the appellant was still in the process of leaving the scene when that happened, and it was a very short period of time. He immediately left.
When would a crash end then, under that scenario? You're
He
saying
was-
that it started.
Yes.
I mean, he backed into the car, he left, assuming that he drove down the road and there's a car chase and everything else. I mean, you're saying that this is still part of the initial crash.
Because
when would it end?
Because he was still in the immediate vicinity of the crash. He was so close that the victim ran to him, sprinted to him, and was there. He drove 20 feet away from the crash and took basically a U-turn and was then in front of the crash at a traffic light.
Do you have any case law to support that argument? What's your best case to support that argument?
The argument that I just made?
Right.
Well, I have a case that, well, Your Honor, I didn't cite any cases because I didn't argue insufficiency of the evidence in my brief because it wasn't an issue raised on appeal. But I will say that there is case law that says that leaving the scene of an accident is a continuing offense. And to answer your question about when does this ever end, it ended when he actually left the scene, when that light turned green, and he, after he dragged the victim 50 feet, and then,
How big is
then
the
he
scene
left.
then? So, I mean, the impact with the two vehicles was in a parking lot.
Yes,
And then the second sort of incident, or as you're arguing, the continuation of the incident was not in the parking lot. It was in the public right-of-way, right? At a
correct.
light. So how big is the scene in this case?
it was close.
You-
It was the same traffic light.
You bump into somebody in a parking lot. How big is the scene? Is it the parking lot? Is it a mile?
It's not a mile.
Is it a half mile?
I think in this case, we're talking about the
Is
same
it as far as
traffic
somebody can
light.
sprint?
We're talking about the same traffic light, Your Honor.
No, we're not, because the bump you're talking about, or the impact you're talking about, took place in a parking lot. That's not
Yes.
that's not a traffic light.
They were waiting in line for a traffic light.
How far away was the traffic light?
4 or 5 cars back?
Didn't he actually leave the parking lot and come back into the parking
He
lot?
did. He left the parking lot and went back to the same light, just at a different,
But he was in the road then, not in the parking lot.
Was.
So how
He
far
was.
away from the parking lot would we go? Draw us the line, because, that's what we're going to have to do, right? If we write an opinion, we're going to have to draw a line. How big is that scene?
I would speak more in terms of time. This all happened basically one event after another very quickly. Mr. Cowan ran to the car to get the license plate. It all took place, in a matter of minutes, if not seconds. But
So do we analyze that argument based solely upon the amount of time that's elapsed? And if so, how much, where's the line that we draw for the amount of time?
Your Honor, respectfully, I believe that this issue needs to be analyzed under a fundamental error analysis, and not just simply a insufficiency of the evidence
Well, if there was no
analysis.
crash in this case,
Yes.
then seems to me that's an element of the crime. There has to be a crash, and if there was no evidence at all to support one of the elements,
Yes.
how is that not fundamental error?
Well, if you look at the holding in FB about what fundamental error is, it's not simply the absence of evidence on one element. It goes further than that. Fundamental error reaches down to the validity of the trial itself. It's a denial of due process, that no crime was committed at all.
Well, if there was no evidence that one of the elements was present, what case do you have where there was no evidence whatsoever on one of the elements of a crime, and yet the court concluded that wasn't fundamental error? How do we get there?
Well, I would say the case FB itself. There was no evidence of the element of the value of the property. No, the state presented no evidence at all of the value of the property.
Well, didn't that change it from a higher level theft to petty theft?
But the trial court, but the appellate court did not reduce it to a petty theft.
But the crime had been committed.
Yes, and
If there was no crash here that resulted in personal injury, what crime was committed where, as alleged in your information, the victim was the husband?
there was sufficient evidence that an aggravated battery was committed, for one thing.
The jury found him not guilty of that.
Yes, sir, the jury was acquitted.
So still no crime. If there wasn't a crash, what was the lesser crime that was committed then?
I stand by my prior arguments that the victim being impaled in the steering wheel, and the steering wheel being part of the vehicle, and then being dragged 50, 60 feet by the steering wheel is sufficient impact between the steering wheel and the victim to constitute a crash.
But we're saying in a world where there was no evidence of a crash, in that world, in that scenario, what was the lesser crime that makes this not fundamental error? We're talking about whether this is fundamental error. Your argument was, well, look, just because there's not evidence of an element doesn't necessarily mean it's not fundamental, because there could be a crime still committed. Well, we're asking you, what's the crime if there was no crash?
The crime is either aggravated battery, because there was sufficient evidence.
The
of
jury
aggravated
rejected
battery.
that.
I understand that, but
Well,
the point,
what's the other crime then?
the continuing course of conduct that started with the crash at the scene, and that resulted in Mr. Cowan's injuries before the defendant left the scene. You know, these principles of fundamental error and preservation, as the Supreme Court said in FB, are very important. They serve a vital role. Cases should not be found to, error should not be found to
Let
be.
me go back to my prior question. If they
Yes, sir.
had properly argued this at the motion for judgment of acquittal, and the state said, well, Judge, we want to reopen,
Yes.
what would you have asked to reopen? What would,
The victim's testimony about the period of time that happened when he was impaled in the steering wheel, to glean more information about that. One of the law enforcement officers said that he saw an injury on the victim's arm, could be related to him being impaled on the steering wheel.
All right, thank you. Your time is up.
Thank you.
I don't believe the state can cite any case that defines a crash as my colleague wants this court to define a crash today.
Well, before we get in the crash argument, if we were to determine that the issue was not properly preserved at trial, and if you did not raise fundamental error as the grounds on appeal, what do we do with the case?
Well, I would like to think that the goal of the court is to correct whatever error may have taken place. And if the error was fundamental at the trial level, if the error was in direct conflict with the Daughtry case, which I believe that it is, I would like to think that this court could correct that error.
Well, let me ask you this. If it had been properly raised at trial, could the state have asked to reopen the case?
Sorry, Judge?
Could the state have asked to reopen the case if the argument below on the motion for judgment of acquittal had been clear, saying there was no collision, there was no contact between the car and the victim, and the state said, well, fine, Judge, we'd like to reopen the case. Would the state have, could the trial judge have allowed them to reopen?
I suppose so, but I think the greater issue there would be what else would they provide? Mr. Cowan and Ms. Cowan testified at length about what it was that occurred. Mr. Cowan's testimony was quite lengthy as to going out into the road, and I appreciate that my colleague wants to use the word impaled, but I don't think anybody at the trial said impaled. I think what he said was that he reached in and he stuck his arm through the steering wheel to get to the keys. To use the word impaled, I think, has some other connotations to it, that he was somehow affected, struck, harmed, injured, and that's not
What if he had
place.
said he had a bruise on his arm from where the steering wheel came into contact with his arm? Would that have been enough to establish a crash?
I don't believe so, no. I don't believe there's any case that defines a crash as having your arm bruised from being inside of a steering wheel. I'm not aware of any such case. I suspect if the state had found one, they would have made this court aware of that. I'm not aware of any. As to that particular argument, the only injury also was as to Mr. Cowan, not Ms. Cowan. There is some testimony in the transcript about Mr. Cowan going to the hospital, but only because his wife was taken to the hospital, which, by the way, was something Mr. Edwards was not charged with, causing an injury to Ms. Cowan. In the Daughtry case that I've referenced several times, there it says the defendant was charged with leaving the scene of a crash involving death. Charges arose from a confrontation between the defendant and the victim while the defendant was sitting in the driver's seat of a vehicle parked in a driveway, and the victim was attempting to enter the vehicle through an open window. The defendant backed the car out of the driveway in an attempt to avoid contact with the victim, and as he accelerated to leave the area, the victim, who was holding onto the vehicle through the open window, fell to the ground, sustaining a fatal head injury. But for the fatality, that fact pattern is remarkably similar to what we have here. As to the scene or the distance, I believe the testimony from both Mr. Cowan and Ms. Cowan was that Mr. Edwards went north through the parking lot from 75 to 100 yards, exited the parking lot, then made the U-turn, and came back that 75 to 100 yards. It was not the 20 feet that my colleague wants to suggest. It was certainly much different from that. As to the jury instruction, I believe both the Williams case and the Stannard case state that all we have to do is put forth any amount of evidence, and at that point in time, if we request the instruction, it should be read.
All right, thank you very much. Your time is up. Thank you both.
Thank you.